Hello and welcome. My name is Peter Afrasiabi. This is me. Well, sort of, it's my avatar. I recorded a short audio and video snippet of content of me and then can recreate myself and my voice through software. So while this is certainly amazing, it is not AI at work on me nor a deepfake of either me or my voice. Instead, you may call it a real fake, I guess. All the content you hear is mine and the voice is mine and the person you see is me. Just it is me digitally recreated, and fittingly, we are using this technology in a program that explores the challenges of the technology as we enter this AI world. I am an intellectual property litigator at the law firm of One LLP with offices in Newport Beach and Los Angeles, California. My practice focuses on copyright, right of publicity, trademark, and related privacy torts. I also teach as an adjunct at the University of California Irvine School of Law, where I teach a Ninth Circuit Appeals litigation clinic with my students, as well as advocacy and persuasion courses. I have taught advocacy at the National Institute of Trial Advocacy and taught advocacy to new barristers at Oxford University in England. But keep in mind, all of the views expressed in this video are mine and mine alone, and are not the views of my law firm, the university, or any other academic institution or entity I work with. Today, we will look at a variety of issues from the new AI technologies and explore the question of how AI may be facilitating the theft of our personhood rights by running over our basic right of publicity interests, and how AI may be misleading us or encouraging suicide in state efforts to address this. We will look at questions about federal and state legal regimes, how to regulate it, efforts underway to regulate it by states that are getting increasingly concerned, and existing legal regimes that do touch on it already. And we will see both good and negative uses of it by right away looking at two of our famed actors, Val Kilmer and Scarlett Johansson, and seeing the technology at work as it applies to voices. So sit back, enjoy a cocktail while I have a virtual one, and let's get going. Let's do a quick overview of the law and where we are going today. We will look at a variety of AI issues. This includes deepfakes, but it also includes other aspects of AI at work, such as consumer AI interactions with AI chatbots, AI therapy, and safety concerns about AI. We will look at some existing state laws on personhood rights that protect us from being overtaken by AI, but we will also explore their limits and the issue of the need for a uniform federal right. And because of the concerns states are seeing at the ground level, we will see various states and their proposals as they try to control this rapidly developing AI world. And against that, we will see the federal executive policy of not wanting too much state regulation so as to ensure American dominance in AI as against foreign businesses or countries. The result we will explore is that there are battle lines now being drawn between states and the executive, and we are waiting for Congress to do something at the federal level. We will start with a look at Florida and Governor DeSantis' comments about AI getting out of control and his desire to see state regulations to protect people. Here's what the governor said in late 2025. Let's not try to act like some type of fake videos or fake songs are going to deliver us to some kind of utopia. He spoke against what he calls the mindless slop AI creates and warned deepfakes and manipulation could pose a potential existential crisis for self-government. He said, quote, "The idea of this transhumanist strain that somehow this is going to supplant humans and this other stuff, we have to reject that with every fiber of our being." This has set Florida somewhat against the federal government's current pretty free market approach to AI on the issue of how and where it should be regulated at the federal level. Or if not at the federal level, how states can act to curtail AI encroaching on our human-based personhood rights. DeSantis has thus, as of 2026, introduced a series of state laws to try to restrict AI. He introduced a slate of recommendations for Florida lawmakers, calling on them to require companies to notify consumers when they are interacting with AI, prohibit the use of therapy or mental health counseling through AI, and give parents more controls over how their children use the technology. Now, the street-level state concerns that AI is giving birth to go beyond stealing our name or likeness. States have begun targeting consumer-facing AI interactions such as chatbots, AI companions, and algorithmic pricing based on consumer personal data by requiring clear disclosures, safety protocols around high-risk use such as minors, and limits on use of personal data. States have also begun to address AI content transparency by requiring developers, platforms, and advertisers to disclose when content is AI generated summarize AI training data, and display warning labels tied to AI-mediated or addictive experiences, especially for young users. Some states and cities are also looking at automated AI tools such as AI resume screeners, interviewing tools, HR tools that are used to manage and evaluate people, and other tools that substantially assist or replace human discretion as an early area for AI regulation. Emerging laws and bills in New York City, Colorado, Illinois, and New York State are looking at these areas too. California passed in late 2025 SB 243, the first law in the nation, that requires AI companion chatbot operators to implement protocols that detect and address user-expressed suicidal ideation or self-harm. It also mandates that chatbots inform minors of their AI status every 3 hours and requires annual reporting to the state's Office of Suicide Prevention regarding these protocols. It creates a private right of action for violations. We will look at this law in more detail later in the program. On the other side of the state and federal divide, on December 11, 2025, President Trump signed an executive order titled Ensuring a National Policy Framework for Artificial Intelligence. This executive order signals an intent to consolidate AI oversight at the federal level, counter the expanding patchwork of state AI rules, and maintain U.S. global AI dominance by 1. Discouraging states' authority to regulate AI through litigation, spending, and standard-setting levers. 2. Targeting state regulatory action in areas such as algorithmic transparency, bias mitigation, and regulation of high-risk AI uses. And 3. Promoting minimally burdensome national AI standards. The order itself does not preempt or override current and enacted state AI laws, and so it still leaves the federal field open and in need of further federal action from Congress. Here we see the executive order's language. The described purpose is built on the idea that the United States leadership in artificial intelligence will promote United States national and economic security and dominance across many domains. To win, United States AI companies must be free to innovate without cumbersome regulation, but excessive state regulation thwarts this imperative. It goes on. First, state-by-state regulation by definition creates a patchwork of 50 different regulatory regimes that makes compliance more challenging, particularly for startups. Second, state laws are increasingly responsible for requiring entities to embed ideological bias within models. The core premise is then that a national standard is needed. And until Congress acts, the executive will take action to check what it sees as the most onerous and excessive laws emerging from the states that threaten to stymie innovation. So what is driving this rapid set of concerns in the law over AI? What is setting up this battle between federal and state regulators? Largely, although not exclusively, it surrounds deepfakes and how AI can make fake copies of us, our voices, our likeness, and then use those fakes for sometimes illicit purposes, sometimes just silly or parodic purposes, or in revenge porn type situations. This requires us to explore deepfakes and what they are, and also look at the current legal regime for our personhood property rights in ourselves. We will start and look at real-world examples of deepfakes to understand what they are and how they work. The first question is, what are they? Deepfakes are AI-generated videos, images, or audio that convincingly depict real people saying or doing things they never did. This raises for us as lawyers, of course, real legal issues. It presents novel challenges to intellectual property frameworks and state publicity rights structures. We will look today at existing laws on the books to regulate deepfakes, and then a range of new state and federal laws being passed or pending to address deepfakes as legislatures race to catch up with our technologists. All of this raises fundamental issues about ownership and adequacy of existing legal protections in this rapidly evolving AI age. So let us begin, as I promised earlier, with two examples of the technology that sits beneath deepfakes, one positive, one negative, one of a consent use that shows how great this technology can be, and one a use of the technology in a deepfake sense to arguably evoke an actress's voice and persona. First, a positive example of this technology out of the gate. This is the situation involving Val Kilmer, and this is a positive story as it relates to the legal regime, as well as just being a positive feel-good story. But specifically, it's a situation of artificial intelligence learning Val Kilmer's voice with his consent. So, What you need to know by way of background, if you don't already know it, is that the famed actor Val Kilmer had some sort of an illness that had damaged his vocal cords such that he could not speak in his familiar, well-known voice. Now, 20 years ago even, that would be the end of an actor or a voice actor's career. But not anymore. With artificial intelligence, because Val Kilmer was able to have his voice recreated by listening to and learning off of historical recordings of his voice, by way of a company called Sonantic. Check out this YouTube video, which will show you the most amazing technology in terms of voice and artificial intelligence.
We all have the capacity to be creative. We're all driven to share our deepest dreams and ideas with the world. When we think of the most talented creative people, they speak to us in a unique way. A phrase we often hear is having a creative voice. But I was struck by throat cancer. After getting treated, my voice as I knew it was taken away from me. People around me struggle to understand me when I'm talking. But despite all that, I still feel I'm the exact same person.
Now there you saw the case of consent, and a really positive application of the technology to allow an actor to continue to work even when his voice was gone. That is, his humanness in his voice merged with these advanced AI technologies to allow him to live forever. But I also want to stand and deliver out of the gate and show you the opposite case that we will be exploring as this program continues today. Let's then take a look right away at the Scarlett Johansson voice situation that led to a controversy because it was not done with her consent. I'm not going to answer all your questions right now about how this AI collides with the right of publicity, but they will all be answered by the end of this program. So check out this video released by OpenAI showcasing their virtual assistant named Sky. You need to watch and listen to this to understand the legal and factual questions the law will need to answer. That voice you hear is not Scarlett Johansson's, but if you listen, it really does sound like her, at least if you ask me.
From right of the ChatGPT app, and this will open up GPT-4o's audio capabilities. Hey, ChatGPT, I'm Mark. How are you?
Oh, Mark. I'm doing great. Thanks for asking. How about you?
Hey, so I'm on stage right now. I'm doing a live demo, and frankly, I'm feeling a little bit nervous. Can you help me calm my nerves a little bit?
Oh, you're doing a live demo right now? That's awesome. Just take a deep breath. And remember, you're the expert here.
Please remember that voice as we now dive into the right of publicity and AI. As a quick overview of our current legal landscape, we start at the top of the pyramid where there is the least amount of federal laws touching this area. Some laws that may touch it are the Lanham Act, Copyright Act, some federal telecommunications acts, and Communications Decency Act in terms of material that's defamatory sitting on service providers' platforms and the difficulty of getting that down or holding them liable. All of those laws touch at some level some of the deepfake issues, but they don't get at the root issue that's related to our deepfake inquiry. We won't go into deep detail on these existing laws, but we will look at pending federal laws to address this on a national level as it relates to deepfakes created by deepfake technologies. This brings us to state right of publicity laws. And here we have the regimes that exist to protect against commercial misappropriation of someone's name or likeness or image or voice. Here we will look at the existing legal playing field as it relates to state laws, and then we will look at new state laws that have been passed to address deepfake situations. Finally, at the bottom of the pyramid is existing state tort laws that deal with defamation and infliction of emotional distress and the like. Those all are subject to our federal laws that restrict suits at least against service providers with broad stroke of immunity under Section 230 of the Communications Decency Act. The point for you here is that we have a very fragmented playing field in terms of the legal landscape that applies. There is no comprehensive all-in-one federal law that actually addresses deepfakes head-on, And this creates fundamental challenges for people who are seeking protection, and at the same time, for companies that genuinely want to avoid different and inconsistent liability regimes so that they can do the right thing. One of the questions that ultimately calls for is whether it is time to nationalize the state right of publicity, along with the sexually explicit deepfake laws, and preempt the field with a universal federal cause of action. Let's look quickly at the online immunity laws in Section 230 of the Telecommunications Act. How does this federal law we see here relate to deepfakes? Here is how it does. When deepfakes go up on social media platforms, getting them down really matters. And the service provider has a range of immunities from state legal regimes. This explodes in the deepfake era, of course, so let's look real quick at the federal laws to understand their deep immunity reach, for the service providers, that is. So Congress, way before deepfakes, and really even the internet as we know it, enacted Section 230 of the Communications Decency Act in 1996. We see it here on this slide, and it is codified at 47 U.S.C. 23C, and this is the money language we have quoted for you. This is the core of what is central to online internet immunities today. Quote, "No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider." End quote. If you read it twice, if you have to, you see it is very, very broad in terms of absolute immunity. And further provisions provide that it ends up preempting any and all state claims based thereon. Here's the definition of what an interactive computer service is. And that's the same basic definition we're using for online service providers as we talk about this in the copyright realm, which we will address soon. But basically, quote, interactive computer services, end quote, refers to information services systems or access software providers that provide or enable computer access by many users to a computer server, including a service or system that provides access to the internet, and such systems operated or services offered by libraries or educational institutions. It's very, very broad, and so what it means is it's Verizon or Cox Internet, it's Yahoo, it's Google giving search, giving email, kind of the backbone access provisions. And then in the more modern Internet 2.0 world, Facebook, Instagram, Snapchat, those types of businesses that have gone a step further but are still built on facilitating communication between people over the internet. Let's go to the next slide, which brings us to the twin goals of Congress with the Section 230 immunity. The first goal was that Congress wanted to encourage the unfettered and unregulated development of free speech online and to encourage e-commerce and its development online. The second goal by enacting this immunity provision was to, quote, encourage interactive computer services and users of such services to self-police the internet for obscenity and other offensive materials, end quote. These are two massive goals that frame the statute and its interpretation over the ensuing decades. This brings us now to one of the first major cases to come down after the law's enactment. And it's really one of the foundational cases. This is the case of Zeron versus AOL. And so now we're bouncing from Prodigy, which precipitated the need to pass the Communications Decency Act provisions, to AOL, which was one of the first ones to be sued after they were enacted on a state tort liability theory. And this case involved an unhappy plaintiff because this is what happened, as you see in the facts. There was a false advertisement placed on an AOL bulletin board, and the false advertisement directed users to call up the plaintiff. And, this obviously resulted in the plaintiff receiving endless amounts of harassment and calls and whatnot at his phone number. Plaintiff was not happy, as you can imagine, being bombarded by harassing phone calls, and so the plaintiff sued AOL saying, "This is your bulletin board. My personal phone number was published on it, and it's obviously harassing, and given the content and nature of it, you should have taken it down. You didn't, and that resulted in me suffering emotional distress and other state tort-based claims and damages." Plaintiff sued, and here is what the Fourth Circuit held. Congress recognizes the threat that tort-based lawsuits pose to freedom of speech in the new and burgeoning internet medium. But the imposition of tort liability on service providers for the communication of others represented for Congress simply another form of intrusive government regulation of speech. Thus, Congress made a policy choice not to deter harmful online speech through the separate route of imposing tort liability on companies that serve as intermediaries for other parties' potentially injurious messages. The case thus held immunity. And so one of the central lines that traverses that holding, as you can see, is that AOL is simply an intermediary. It's a facilitator of communication. It is not really engaged in curating the content and editorializing the content. In publishing the content the same way the New York Times makes those conscious, volitional business decisions about what content it's going to publish, it's really an intermediary. That is, it's just a service provider providing a means of communication. Therefore, if I defame you, then you can sue me. You can do your discovery, and you can find out who I am, and you can go after me the same way you have always been able to go after me under state tort law. You just can't hold the internet company liable. This case is a seminal foundational case when it comes to online social media liability principles. Let's apply it to AI. You can immediately see the dilemma we confront with these online providers and their immunity as we enter now a world with AI bots running over the carriers or deepfakes spreading on their systems, potentially causing immense damage. Let's now address the state right of publicity regime that most directly relates to our AI creation world and deepfakes. This right against another's commercial misuse or misappropriation of one's likeness existed at common law in various states over the subsequent decades, and began being codified as positive law in various states also. It's now recognized in over 35 states, and what is critical to keep in mind is that this is a distinct right to copyright or trademark, even though it has similar issues and touches on similar concerns. The existence of this right in the state courts eventually reached the U.S. Supreme Court in the late 1970s. This was a case involving the famous human cannonball. You can see the case there, the case and its citation, so you can read it later, but basically what happened is as follows. The human cannonball had an act that he made money performing. He would drive his large truck that had a cannon attached to it, wear his cannonball suit, climb into the cannon, and then get fired out of it. He would fly through the air, flip, and land. That was his whole persona. It took only 15 seconds, and he made his living by charging to watch the short event. So for him, the 15 seconds were everything. What happened is that a reporter video recorded the whole act and played it on the news. The human cannonball then filed a lawsuit under Ohio's right of publicity laws claiming that his persona, that is his act that he did, was that entire short sequence, and showing that to the public abridged his rights. The news organizations claimed a First and 14th Amendment right to broadcast this as news. But the Supreme Court rejected that argument and found that he had that right that was free from constitutional barriers to exploitation. Now, what is important for our modern artificial intelligence age, in light of the fact that the U.S. Supreme Court has only addressed the right of publicity and the First Amendment one time, is the fact that the decision was a 5-4 decision. And the legal fault line the decision hinged on was the fact that the news organizations engaged in conduct that amounted to an entire taking of his performance, as opposed to merely reporting upon it, which would not require such an extensive taking, arguably. This is what the U.S. Supreme Court said. Wherever the line in particular situations is to be drawn between media reports that are protected and those that are not, we are quite sure that the First and 14th Amendments do not immunize the media when they broadcast a performer's entire act without his consent. On the other hand, the 4 dissenting justices took the position that it was genuinely news activities and therefore protected by the First Amendment. The dissenters stated as follows, quote, "There is no suggestion here that respondent made any such use of the film. Instead, it simply reported on what petitioner concedes to be a newsworthy event, in a way hardly surprising for a television station by means of film coverage. The report was part of an ordinary daily news program consuming a total of 15 seconds. It is a routine example of the press fulfilling the informing function so vital to our system." End quote. The decision was from the 1970s, but here is the breakdown of who the dissenters were. This is important to us as IP and right of publicity lawyers, because we want to try to read the tea leaves about how today's court would rule. The 4 dissenters were Justices Marshall, Brennan, Stevens, and Powell. In other words, the liberals of the court of that era by and large. Now, the majority was Justices Berger, White, Rehnquist, Stewart, and Blackmun, the conservatives by and large. But you will note that it was not a purely right and left split, given where Powell and Blackmun came down. So it is an important decision, but we can also see that it was a very closely decided case that hinged on a very unique and arguably extreme fact pattern in terms of the entire taking. Nonetheless, this decision really coincided with the floodgates opening in reality to the modern right of publicity age in terms of protections and monetization of it. This has led to further enactments of laws in various states, which also include rights in some circumstances for broadcasting, but not the right for a complete taking of someone's persona in general. So let us now unpackage this right a little bit more. We will look at the California statutory right, which is codified in California Civil Code, Section 3344. It protects against an unauthorized use of a person's name, likeness, voice, signature, and/or photograph in commercial advertising. Subsection A provides that any person who knowingly uses another's name, voice, signature, photograph, or likeness in any manner, on or in products, merchandise, or goods, or for purposes of advertising or selling or soliciting purchases of products without the consent of the owner, is liable for damages. There are augmented damages and punitive damages available, along with attorney's fees also. So it is a powerful right that gives remedies if it is abridged. And as applied to deepfakes, it applies foursquare to digital AI-based deepfakes, created and then used commercially. But note it has limits, as it is a right that protects against commercial exploitation. Its application, for example, to deepfakes that are revenge porn type things that do serve a commercial purpose may make regulation of such acts of appropriation outside the statutory framework. As I mentioned before, there are some statutory limits that have been enacted. For example, California has an explicit exception for uses in connection with any news, public affairs, or sports broadcast or account, or any political campaign. This allows news broadcasters to show, for example, athletes either in public or in clips of them playing, without being sued by them for right of publicity. But remember, the human cannonball case still stands as good law, so a complete taking of someone's persona, which is their entire economic persona value, would create an issue. There are further statutory exemptions from liability for uses in a play, book, magazine, newspaper, musical composition, audio-visual work, radio or television program, or other types of newsworthy events. This is where the First Amendment has been enshrined and protected as a limit on the scope of the positive right, so that, for example, documentaries and biographies can be made of famous people without tripping state laws. Even then, of course, as an intellectual property lawyer, I can tell you that we regularly confront the issue of whether a use is too extensive and whether rights should be cleared to avoid even uncertainty of potential litigation. And for those of you back east, New York is similar with similar laws that it has codified and enacted in recent years. To understand AI and deepfakes and how the law may apply, here is what we could call an analog world deepfake case. In the 1980s, we can consider the case of Bette Midler versus Ford, which went up to the Ninth Circuit in 1988, and you can read the opinion at 849 F. 2nd 460. Let me give you the facts before we actually watch the commercial that upset Midler. Ford Motor Company wanted to do an ad campaign for its Mercury Sable car that was meant to inspire nostalgia for the 1970s. As a result, it wanted a famous 1970s song to be sung by the original artist who recorded it. It chose the song Do You Want to Dance, which was one of the songs Midler recorded on one of her commercial music albums. Ford cleared the copyright interests from the copyright holder of the musical composition, which was not Midler, and it then asked Midler to record the song for the commercial. She did not want to do it, and so as a result, Ford hired a voice impersonator and had that person sing the song. And Ford also did not use Midler's name or image in the commercial. In other words, it did not use someone who looked like her and perhaps danced like her. It got a sound-alike. Let's now watch the commercial. I have only shown you part of it, enough for you to get the idea of what was happening as it relates to a voice impersonation claim. If you want to see it all, YouTube has it for you at the link.
Do you wanna dance and hold my hand?
Now there's a car that just asks to be driven.
You're my lover man, oh baby.
Mercury is bringing a sophisticated new shape to the American road.
Wanna dance?
Introducing Sable.
Do you
shape you want to be in.
Well, there you have it. And what did the Ninth Circuit hold? You can see the holding there, which sums up the right of publicity standard pretty well. The court held, why did the defendants ask her to sing if her voice was not of value to them? Why did they studiously acquire the services of a sound-alike and instruct that sound-alike to imitate Midler if Midler's voice was not of value to them? What they sought was an attribute of her identity. Its value was what the market would have paid for her to sing the commercial in person. And here is a key line, which now echoes through the decades to our modern day. The human voice is one of the most palpable ways identity is manifested. The Ninth Circuit also addressed these First Amendment concerns that we have already alluded to in the human cannonball case and in the statutory exceptions by noting that the First Amendment is broad and gives a lot of leeway to the press. But where the purpose of a use in media is informative or cultural, then that use can be immune in terms of First Amendment news-gathering issues. But if the use of a person's identity is centrally related to exploiting the individual portrayed for commercial gain, then the First Amendment gates are essentially slammed shut and there will be no immunity. This is a massive case in the realm of voice that has long-lasting consequences as we enter the artificial intelligence age, where voices can now be recreated without having to hire expensive imitator actors. Finally, it is also worth mentioning what happened after the Ninth Circuit remanded the case. Well, it went to trial, and the jury awarded Bette Midler $400,000 in damages. The defendants appealed it all the way to the United States Supreme Court, but the Supreme Court refused to take up the case. So it was not a computer that made the voice and was a person meant to be like her, and rather than use an AI machine, a real actor was used. Put differently, it was an analog-era deepfake, basically, and they lost. That will help us understand AI and deepfakes as we get to technology creations of voices and answer the Scarlett Johansson question. So now let's enter the 21st century and the realm of artificial intelligence and the Scarlett Johansson situation we looked at earlier to see how these precedents from our analog world may apply in the AI world. In 2024, the facts as publicly reported appear as follows. OpenAI asked her if they could use her voice as a voice in the artificial intelligence systems they were creating. Imagine something like Siri that we all know from our Apple phones, but far more advanced. She declined. Nonetheless, OpenAI then released its most recent version of ChatGPT with a voice assistant who goes by the name of Sky. When the commercial was released, many people felt as if Sky sounded like Scarlett Johansson. She certainly did, and it is reported that she hired lawyers and complained. No doubt her lawyer's letter cited the Bette Midler case. Here is the commercial again, so you listen for yourself and make your own decisions about the legal and factual questions of similarity and use. We will then discuss it within the right of publicity framework. Here you go.
From right of the ChatGPT app, and this will open up GPT-4o's audio capabilities. Hey, ChatGPT, I'm Mark. How are you?
Oh, Mark. I'm doing great. Thanks for asking. How about you?
Hey, so I'm on stage right now. I'm doing a live demo, and frankly, I'm feeling a little bit nervous. Can you help me calm my nerves a little bit?
Oh, you're doing a live demo right now? That's awesome. Just take a deep breath. And remember, you're the expert here.
To me, it does sound like her indeed. Now, to be clear, this is not a slam dunk. Many people, when you read online discussions, say that it does not sound like her. This gets to one of the core fact issues that exists in these AI voice cases. Is the second voice, in fact, an imitation of the first voice? We don't know what happened in the conversations between her lawyers and OpenAI, of course. But Sky has been taken down in terms of that voice. And this raises a variety of issues. First, was the voice of Sky AI generated, or was it a voice imitator actor? If it was a human actor, then this looks very much like the Midler case, which would then raise the legal questions within right of publicity law of whether this was a knowing use of her distinctive and valuable voice in a commercial manner. After all, they tried to hire her and she refused. This fact is powerful to merge with facts of voice similarity to conclude the second voice is indeed a copy of hers. Second, there still remain complex fact questions about the distinctiveness of the voice. A Midler sound-alike singing a Midler song on those facts seems easier, but it gets harder when a voice is not being used in an associational manner with the person, as was squarely the case in Midler, and just sounds a bit like someone famous. On the other hand, if the voice was AI generated, then it raises similar right of publicity questions. As a factual matter, it obviously gets more complicated because a voice imitator is hired to imitate a voice, and that makes proof of the knowing element easier. But whether the AI machine has learned human voices by listening to thousands or millions of hours of human voice and has generated that voice is a slightly different question. It is harder to prove that it was trained on her voice in particular, or whether it was simply trained on voices, and the voice it landed on sounded somewhat like hers. In other words, was this a knowing use under right of publicity law? So this gets us to AI and deepfakes, and now let's look at the state deepfake laws being added to the books to combat the technologies that are driving these questions. Here we will look at California's newest laws to try to address deepfakes and the broad scope of use of the technology that can inflict harm. The first one relates to politicians, which I guess makes sense since they want to legislate to protect themselves first and foremost, if we are to be a little cynical. Here we have AB 730. It prohibits distribution of materially deceptive audio or visual media of candidates within 60 days of an election. And materially deceptive audio or visual media includes an intentionally manipulated image, audio, or video recording of a candidate that would both falsely appear to a reasonable person to be authentic and would cause a reasonable person to have a fundamentally different understanding or impression of the expressive content than that person would have if they were hearing or seeing the unaltered original version of the content. Then we have AB 602. It creates a private right of action for individuals depicted in sexually explicit deepfake material without consent. Then more recently, we have some new proposed laws in 2024. These address AI-generated election content and require platforms to implement procedures. All are examples of gaps in the law given the default right of publicity framework we looked at. Let's look in more detail now at it. It creates a private cause of action against a person who either 1. Creates and intentionally discloses sexually explicit material where the person knows or reasonably should have known the depicted individual did not consent to the creation or disclosure, or 2. Intentionally discloses sexually explicit material that the person did not create, and the person knows that the depicted individual did not consent to the creation of the material. A depicted individual is an individual who appears, as a result of digitization, to be giving a performance they did not actually perform, or to be performing in an altered depiction. It also exempts a person from liability if the material was disclosed at a legal proceeding to report unlawful activity, or if the material is a matter of legitimate public concern, a political or newsworthy work, or is otherwise protected by the Constitution. A successful plaintiff can recover either economic and non-economic damages proximately caused, including emotional distress, or statutory damages of at least $1,500 but no more than $30,000. But if the act was done with malice, then up to $150,000. Also, punitive damages, attorney's fees, and costs and injunctive relief are available. So this addresses what default state law does not: a non-commercial deepfake and a use that may be more limited, such as circulating among friends improper AI-generated pictures. As it stands in 2025, we have 27 states that have individually addressed AI and deepfakes with some sort of legislation. Have specific ones like we looked at in California, other ones such as Tennessee that have protected voices in particular, and then we have New York, which has actually combined the right of publicity and deepfake regulation and has a more broad-based set of legal protections like California. You can see on the chart here our breakdown of various state approaches in terms of what they are protecting, and you can see the vast majority are specifically addressing AI sexual deepfake situations. Multiple lawsuits have been filed to address restrictions on political commentary in the new 2024 laws we just looked at. Here is California's AB 2839 law. The maker of a Harris parody video sued to get an injunction on the political aspects to California's laws. Here are the facts from the court. His videos contain demonstrably false information that include sounds or visuals that are significantly edited or digitally generated using artificial intelligence. In the video at issue, he used AI technology to make Vice President Harris's voice manipulated to say things she has not said including that she is the ultimate diversity hire, and that she has spent 4 years under the tutelage of the ultimate deep state puppet. And in court, the Harris Paradis got an injunction too. Here is what the court said. Almost any digitally altered content, when left up to an arbitrary individual on the internet, could be considered harmful. For example, AI-generated approximate numbers on voter turnout could be considered false content that reasonably undermines confidence in the outcome of an election under this statute. On the other hand, many harmful depictions, when shown to a variety of individuals, may not ultimately influence electoral prospects or undermine confidence in an election at all. As plaintiff persuasively points out, AB 2839 relies on various subjective terms and awkwardly phrased mens rea, which has the effect of implicating vast amounts of political and constitutionally protected speech. The record demonstrates that the state of California has a strong interest in preserving election integrity and addressing artificially manipulated content. However, California's interest and the hardship the state faces are minimal when measured against the gravity of First Amendment values at stake and the ongoing constitutional violations that plaintiff and other similarly situated content creators experience while having their speech chilled." End quote. Here is what the court then ultimately held. Quote, "While a well-founded fear of a digitally manipulated media landscape may be justified, this fear does not give legislators unbridled license to bulldoze over the long-standing tradition of critique, parody, and satire protected by the First Amendment. YouTube videos, Facebook posts, and X tweets are the newspaper advertisements and political cartoons of today, and the First Amendment protects an individual's right to speak regardless of the new medium these critiques may take." End quote. So here, AI won that battle. So now let us see where Congress is in terms of taking the reins on the federal side and passing some set of laws to address AI. As of 2026, there is a broad pending federal landscape. So we will look at some of the pending federal laws, starting with the No Fakes Act. The No Fakes Act is probably the most comprehensive federal effort to address deepfakes. It was introduced by a bipartisan group of senators including Chris Coons, Marsha Blackburn, and Amy Klobuchar. This bill would establish the first federal right to control one's own image and voice. It recognizes that every individual has a federal intellectual property right to their own voice and likeness, including an extension of that right for the families of individuals after they pass away. That is a very broad nationalization of the otherwise state-based right to publicity. At the same time, it includes safeguards intended to protect First Amendment rights for protected speech such as biopics, docudramas, parody, and satire. A second one is the Defiance Act. This represents another significant federal proposal aimed specifically at sexually explicit deepfakes. The bill would create a federal civil remedy for victims of non-consensual sexually explicit deepfakes, allowing them to sue those who create, distribute, or possess with intent to distribute such content. It defines non-consensual sexually explicit deepfakes as visual depictions created through technological means to falsely appear authentic that depict a person in the nude, or engaged in sexually explicit conduct or sexual scenarios. So as you see, this is similar but narrower as it is focused on sexually explicit creations. Let's now look at another one called the Deepfake Accountability Act in more detail. This act, if passed, creates a legal obligation for those who create deepfakes through generative artificial intelligence and do not label the video or audio file as having been made through AI. It applies to both living and deceased people. And a deepfake is defined as having been made by generative artificial intelligence, whereby it appears to authentically depict either the speech or conduct of a person who did not engage in that speech or conduct. Note, however, it does not apply to voice actors who do verbal impersonations. I won't read the whole definition for you, but you can see it here for a few moments and study it further in the materials. If someone makes such AI deepfake content and does so with the intent to distribute it over the internet, or even with knowledge that it will be distributed over the internet, then they must make sure that the file clearly identifies itself as being made through technology with altered audio or visual elements or having been created by AI. There are specific labeling requirements the law will require in terms of a verbal statement that identifies the use of artificial intelligence, as well as a clear written statement in readable text throughout the whole video, identifying it as having been made by artificial intelligence. And no, this does not mean you can make deepfake porn of people and just label it. Sexual deepfakes are to be per se outlawed. I have bolded the content for you to read here that is germane to our discussion today. Moreover, there are provisions for civil liability. These actually track somewhat existing remedial structures that exist in the U.S. Copyright Act. And what the statute as envisioned provides is that if someone has been exhibited and engaging in activity that is falsified by way of deepfake technology, then they may seek damages and injunctive relief in federal court. The statutory damages structure includes a $50,000 penalty, a $100,000 penalty potentially if the conduct was more extreme, and a $150,000 penalty if it is deepfake content involving sexual activity or nudity. The damages include both actual damages, but then also the statutory damages regime similar to copyright infringement liability damages regimes that exist for copyright statutory damages, where the awards can be to an extent divorced from actual harm and are focused on deterrence and punishment. And there are broad injunctive relief powers available to federal courts to enforce the laws. And as a word of warning, do not let your clients think that until this law is passed, that they are operating on a blank check to do what they want as it relates to artificial intelligence technology. Aside from the state right of publicity laws that we have discussed, there are a variety of state laws that various states have enacted specifically to address improper deepfakes, particularly in sexual and nudity subject matter areas. Finally, as noted, this is not the only pending federal law. There are other pending bills that seek to achieve similar legislation over the area, all of which legislation amounts to a partial, at least, nationalization of the right to publicity. The legal landscape here is changing rapidly, so stay tuned and watch our programs as we update the state of the law as this develops. Some deepfakes can have good social purposes even outside the consent example of Val Kilmer, or the satire example of the political video of Harris. There is news reporting, social commentary, parody, and satire that needs protection in creative expression. And deepfakes allow people to engage in these activities at a more breathtaking pace than ever before. Not just video, but voice, and then video and voice together gives a technology platform to create in new ways and harm in new ways, and the laws have to balance all interests. The state and federal laws, thus, are all moving incrementally in protecting rights of all stakeholders, not just the first-level victims of a deepfake. Let's look now at the other social areas prompting state regulation. Let's get back to right of publicity now. The major state personhood rights that gives us varying rights in our name, likeness, appearance, and voice. One of the questions that all of these cases have raised, which is even more pressing arguably in this modern AI age, is the need for a federal right of publicity in order to have uniformity. As we have seen in this program, there is a hodgepodge of state-based rights in various states. The states, however, differ in terms of the scope of protection, the types of remedies one can get, as well as whether there is even a post-mortem right of publicity available. Even before the digital age, this created forum shopping issues that can occur. For example, a plaintiff may have a claim in California but not Alaska, and that leads to suits filed in California to avoid risks in Alaska. Or a state may have better damages remedies. Some states even have laws that state anyone in the nation can sue under their statute, assuming minimum contacts over the defendant, of course. Other states do not have such breadth of laws. And states can differ on the scope of the right. California's voice protection may not, for example, reach voices in other states. This creates conflicting state rules on questions as fundamental as whether someone even has a right to begin with. When we contemplate the digital and artificial intelligence world, the problems magnify. Technology that allows videos to be created of people, digital avatars that is, as well as digital voice replications of people, also allows these videos to be disseminated across YouTube, Snapchat, Facebook, all manner of social media rapidly and easily. This includes the terrible cases of deep fake pornography that have been publicized, such as of Taylor Swift and others. And so this too raises the question of the need for a uniform national right. Today, with much greater ease of access to the technology by all people to create digital replicas of others, which in the pre-digital age was not nearly as easy, obviously, we now have the likelihood of far more violations of these rights of publicity. And of course, there is a massive issue. If certain people in certain states lack protection, other people in other states have protection. And even more broadly, if even in states where there is protection, we have situations where people have to go to state court to get an injunction, which may or may not have applicability to social media platforms in other states, and would be very complicated to enforce. All of this has raised real questions about the need to have a national right of publicity, with federal court jurisdiction and nationwide jurisdiction from those courts in order to protect people's rights of publicity. Much has been written in this in legal journals. You can even find an article I wrote on my bio on my law firm's website. In short, artificial intelligence is pressing very hard against the variety of different state law regimes we confront protecting these rights, and is really testing the limits of our current legal landscape. There's a very strong case that can be made that there needs to be a complete nationalization of the right of publicity, similar to the way copyrights, trademarks, patents, and even trade secrets have full federal protections. These federal rights allow faster and more robust enforcement for protection. But will it happen? The pending laws we looked at are aiming to nationalize certain aspects of the right of publicity in certain contexts, but not outright create a national right that just preempts all state laws or sits concurrently with state laws. Personally, I think the time is here to have a national set of baseline rights in our personhood so we are not left to varying state regimes and so that there is a rapid enforcement mechanism in federal court when AI absconds with our personhood. As discussed earlier, states have also begun targeting consumer-facing AI interactions, such as AI companions or bots, and algorithmic pricing based on consumer personal data by requiring clear disclosures and safety protocols around high-risk use and limits on use of personal data. There have many media reports of suicide after AI use, among children too. And this has led to states now looking to tie down regulations in this area. This lets us look at California's SB 243 law that became effective in 2026. This law requires AI companion chatbot operators to implement protocols that detect and address user-expressed suicidal ideation or self-harm. It also mandates that chatbots inform minors of their AI status every 3 hours and requires annual reporting to the state's Office of Suicide Prevention regarding these protocols. It creates a private right of action for violations also. Let's now unpackage this law a bit. Here is what the law mandates. If a reasonable person interacting with a companion chatbot would be misled to believe that the person is interacting with a human, an operator shall issue a clear and conspicuous notification indicating that the companion chatbot is artificially generated and not human. Next, an operator shall prevent a companion chatbot on its companion chatbot platform from engaging with users unless the operator maintains a protocol for preventing the production of suicidal ideation, suicide, or self-harm content to the user, including, but not limited to, by providing a notification to the user that refers the user to crisis service providers, including a suicide hotline or crisis text line, if the user expresses suicidal ideation, suicide, or self-harm. And as to minors, an operator shall, for a user that the operator knows is a minor, do all of the following. 1. Disclose to the user that the user is interacting with artificial intelligence. 2. Provide by default a clear and conspicuous notification to the user at least every 3 hours for continuing companion chatbot interactions that reminds the user to take a break and that the companion chatbot is artificially generated and not human. 3. Institute reasonable measures to prevent its companion chatbot from producing visual material of sexually explicit conduct or directly stating that the minor should engage in sexually explicit conduct. Finally, there is a private right of action for violations of actual damages of $1,000 in damages plus attorney's fees. New York was the second state after the California example we saw to pass in late 2025, effective in 2026 legislation aimed at regulating the safety and governance of frontier AI models. The Act mandates that large AI developers develop and publish information regarding their safety protocols and notify the state within 72 hours of identifying a qualifying safety incident. The law establishes an oversight office within the Department of Financial Services to evaluate large frontier developers and promote transparency. The law also authorizes the Attorney General to bring civil actions against large frontier developers for failing to comply with reporting obligations or for making false statements. Civil penalties are up to $1 million for an initial violation and up to $3 million for subsequent violations. The Act does not authorize a private right of action. Here are our conclusions today as it relates to AI and the state and federal battles over control of AI and its uses, so that you can understand both how to advise clients who may be finding themselves confronting potential liability, or clients who may be victims and need to seek redress in the courts. The technology is incredible and has great power to do social good as well as harm. This risk to our human personhood at the hands of AI is why the states are moving fast to start addressing the issues, as we saw in California and New York's 2026 enactments. The states are filling the void because Congress has not acted and the executive has taken a hands-off approach for policy reasons. Fundamentally, there are existing legal regimes in the states that can address some aspects of AI stealing our personhood, such as in deepfakes, but they are limited both in terms of which states have right of publicity protections, but also in terms of the substantive scope of right of publicity protections. Generally, there is the need for a commercial use which tends to exempt a range of political or sexually explicit revenge porn type deepfakes. This evolving legal framework, therefore, now includes a variety of new state laws that have been enacted to combat deepfakes, as well as several pending federal laws. We looked at all of them, and you can make your own decision about what you think is the best approach. We saw the limited state-by-state approach to the limited federal approach of addressing political speech and sexually explicit deepfakes, all the way to the broader federal approach of essentially providing nationwide full right of publicity type protection, almost preempting or supplanting the state regimes. One of the through lines we saw that really goes from the inception of state right of publicity ideas all the way through the pending federal laws, the new state laws, and the case law that we looked at is the importance of balancing First Amendment expression ideas with protecting against commercial misappropriation or other misappropriation of people's names or likenesses. And that stands against the need to protect minors and people from suicide ideation prompts or other harmful outputs of AI. We saw the language in the pending federal and state laws designed to address those issues. At the same time, we saw in one example, one federal court has already enjoined California's deepfake law as it relates to political speech, finding that people have the right to engage in deepfake technology use to engage in political satire. How these interests continue to be balanced will evolve over time. So stay tuned as you watch for the future development in this area to make sure you are fully aware of the current state of the law. Further, I would submit that federal legislation offers a path towards more uniform protection, and that raises the question of whether we should simply nationalize the right of publicity for both commercial uses, but also for sexually explicit uses political speech, the full spectrum, and thereby have a federal platform with federal court injunctive relief power to address these issues. And as we saw, because of the immunity from state tort law that service providers have, there needs to be in all of these laws some mechanism to mandate takedowns, as we have in the copyright realm when there is a deep fake that is improper that is being used. But as we saw, Congress has many pending bills, has not acted yet, and the official executive order from the White House adopts a hands-off policy for national policy reasons. Thus, we have a federal void, and states then are racing to address the issues they are confronting in their communities as a result of AI. Consequently, we saw states really moving to address the root concerns that they see AI having on our society, such as in chatbots, children, suicide, where states are demanding notice to one when they are engaged with AI, safety warnings, and programmed structures to make sure children do not get pushed into suicide conversations or exposed to sexually explicit material. Those very real state-level concerns are leading to state legislation in the congressional void that exists at the federal level. Again, we saw that at the federal executive policy level, there is a desire to not interfere with AI so as to allow it to develop and allow America to dominate it. This may lead to muted or tepid federal responses, and so the big takeaway here is that the states will be a pool of experimentation with laws to combat the effects of AI as we now are in the future, confronting the issue of whether AI is taking away our personhood rights. Thank you. And, as always, if you have questions, please reach out and email me.